Welcome everyone. So my name is Melinščak Zlodi. I am SPARC Europe chair of the board. I also work on the Retain team, and I welcome you to this webinar organized by both SPARC Europe and Retain team. I would like to ask Jon or Clara to share the slides for the webinar. Okay, thank you. So I will briefly share today's agenda. We will start with a presentation of the project results with a very brief overview of the whole Knowledge Rights 21 program and especially of Retain project. Then I will introduce you to our first speaker, Jon Treadway, and he will present the findings of the project. And later on, we will continue with a panel discussion related to these findings with members of different stakeholders groups. We will present them later before the panel session. And at the end of the webinar, we will also leave some time for all of you in the audience to ask questions. So please, during the webinar, you can freely post any comments or questions you can use chat for that, and we will address all of the questions posed at the end of the webinar. So next slide, please. Let me say briefly why we are here. The main program that we are being part of, and the webinar is actually one of the results of this program, is Knowledge Rights 21. So this is the program that has a very broad mission. It is mainly to address different legal challenges and remove legal obstacles when possible for sharing knowledge freely. So one of the focuses of this program are fair access to books, protection against contract or technology bypasses, or support to research and education, better access to research publications, and of course, protecting authors' rights. We need to mention that the program is very generously funded by Arcadia Foundation, and it is led by 3 organizations, IFLA, LIBER, and SPARC Europe. And we invite you, of course, to look at the website and see the resources that were produced within the program and to get to know a little bit more about what's happening there. So, as I said, there are 2 key missions. One is to enable inclusive and sustainable access to knowledge through libraries, mainly through facilitating fair access to e-books, protecting from contract override. But also there is a broader mission of facilitating research and investment and innovation more broadly, through representing the interest of researchers and making more open and flexible copyright regulation that will enable actually easier access to research, teaching, and learning. So, and in this arena, we are mainly focusing, the program KR21 is mainly focusing on secondary publishing right and on author rights retention. So if we can go to the next slide, I will say a little bit more about this last point, which is author rights retention. This is something that has been addressed with the Retain project. It is led by SPARC Europe. It is now in the 2nd phase, and the project is actually intends to accelerate the uptake of right retention and open licensing, which is also very important, to be able to help researchers to share their work openly. This second phase of Project Retain has actually focused on several types of activities. First is the research, of course, and we conducted research on right retention policies across 10 European countries through in-depth case studies, and you will hear more about that in Jon's presentation. But we also did a lot of campaigning to stimulate more policy changes and, of course, to raise awareness of this issue and to build a European-wide right retention community of practice. So this webinar is actually one of the results of this engagement campaign, and I hope that many of you have also been members of our community of practice, or if you haven't, you will join us in the future. So before going on, I will just introduce our speaker and the member of our project team, Jon Treadway. So Jon is the founder and director of Great Northwood Consulting. He has a long experience in strategic and operational leading roles and extensive experience of strategy and policy development exactly in the domain of scholarly communication. Jon was the principal investigator in the Retain project, and he is the one who can best describe what have we learned in the project. Thank you. And Jon, the floor is yours. You are muted, Jon, just to say.
Jon, you continue muted.
Okay, it's probably the problem with the headphones that we know. No.
I'm so
Okay.
sorry. It's because I was
Okay.
sharing my screen. It was
Okay.
not allowing me to easily unmute. That's a good start. So I will reshare my screen. And I'm so sorry about that. I started talking very happily and didn't realize that I was muted for a few seconds. So thank you very much, Aoife, for the introduction. It's very nice to see. I think there are people still joining, and I've seen lots of names that are familiar to me from the first phase of this project and the second phase. So I hope that people find this interesting and rewarding. I'm going to talk for about 15 minutes before we open it up to a broader discussion with a number of other stakeholders. I'm going to talk about the approach we've taken in the second phase of Retain, why we've done that, and what things we have found as we've gone along. Phase 1 of Retain was undertaken in 2022 and 2023, which was at a point in time where there was a lot of rapid development in this space, lots of movement in different areas, and our approach was to try and survey that across multiple groups of stakeholders, through surveys to institutions, to try and build a map of what was happening in different places. Our approach this time has been different. We have tried to focus much more on activity focused on institutional policy development, so less around funders, how publishers are reacting, and trying to map every development everywhere, and instead spend more time looking in more detail at what's happening in 10 different places, the initiatives that have been launched in 10 different countries. We have found a number of very different things happening through those case studies, and they were deliberately chosen to do that. We have 2 countries where many of the institutions, and possibly most, in a couple of them have rights retention already in place. We have 4 countries that have existing secondary publishing rights legislation, and 3 which are considering legislation. 2 of the initiatives are focused on bringing institutions together and providing education and training to them. 2 are focused on institutional dialogue and policy development, following on from secondary publishing rights introduction that was done in the past, and launching policy in the wake of that. 2 approaches are very holistic, considering how to achieve legal reform in parallel with institutional policy approaches, and across the different initiatives that we have surveyed. there is a really broad range of ways in which different stakeholders and different organizations are being brought together. There are groups of libraries, pre-existing coalitions of universities, networks of universities within country, and groupings that have come together for the purpose of this initiative. So stakeholders that have worked together in the past, but who have come together in a unique and particular way to focus on the possibility of rights retention reform, and where it's being done in parallel, legislative reform that goes alongside that. I think it's probably worth, well, I'm going to, because I think it's worth returning to what we mean by a rights retention policy within an institution. This was a definition that we developed in the first phase of Retain, having interviewed a very large number of people and dived into what they were developing and calling a rights retention policy. We settled on an expressed position setting out the practice of retaining sufficient rights for academic works of an institution's employees to make the work immediately and openly accessible and reusable. And that is deliberately a broad definition because it captures a wide range of things that people have put in place to advance the retention of rights by their employees. There are very significant variations in the scope of policies, and in particular what type of policy is in place. It's often not the case that there is a rights retention policy within an institution. It's often a scholarly publishing policy or an open access policy, or covering copyright or even intellectual property. The nature of the mandate can vary quite a lot. Some are mandates. They require a certain action on behalf of researchers in the institution. Some are recommendations encouraging researchers to do a particular thing. Some really only are offering support so that researchers can understand what's required of them by another party, generally a funder, and sometimes putting researcher support in place to do that. Sometimes the rights that are covered, that are being retained, relate to the institution. Sometimes they relate to the researcher in question. That depends on the exact interplay of copyright law and ownership in the country and how it's exercised in practice. All of the policies that we're talking about cover journal articles. Some cover monographs, some cover longer form scholarly works, some have clauses around data and other content. Some apply to just researchers, some apply to researchers in receipt of public funds, some apply to all employees of the institution and students at the institution. And the ways in which open licensing are expressed and required in the policies can vary substantially. I think, again, I would emphasize that we have adopted quite a broad definition, because one of the things that we will see, and I will try and stress, is there is lots of progress in lots of different places, but by necessity it is going at different paces and being done in local context. And to try and adopt a very strong definition of rights retention that implied a particular threshold would have been counterproductive for our purposes of highlighting progress and how people are doing it. And instead, we're trying to offer something here that captures all of the things that we're seeing and the approaches that people are taking. So what have we seen? I put here, I think you'll find it's a bit more complicated than that, which is a T-shirt a UK-based academic called Ben Goldacre developed and offered for any topic that he was talking about or writing about. And I offer that as my own observation, that I'm not I've developed a level of expertise in copyright and some of the policy areas in question, but every time I have tried to abstract from what we're hearing in different places and offer a summary to people, reasonably they say, well, yeah, that's probably right, Jon, but I think you'll find it's a little bit more complicated than that. The level of specific context in which people are operating, the things that they're having to consider, is very, very complicated, to repeat that word, and it's something that keeps coming back as we go. Nevertheless, this is my attempt to offer some thoughts on what we have seen. It is still early days in terms of rights retention, even for the UK and Norway, which are the two countries that we feature in case studies where there are lots of policies in place across lots of institutions, and they have been for a couple of years. It is still early in terms of being able to say what impact they have had. There has been an impact. There has been a measurable impact. Tromsø and the N8 who we feature can point to the impact that their rights retention policies have had on materials that are being made openly accessible. But for even in those countries and across all the other ones that we consider, it is still very early to say what impact they will have. The benefits that people anticipate are clear, and we will see how they play out over time. But it is difficult to offer concrete conclusions over what will happen as a result of all these policies as a result. In most of the case studies, we're looking at the groundwork that is being put in place to help facilitate more policies being put in place, the frameworks that will establish them, initiatives that are encouraging people to develop them and understand what framework, what options they have to do so. See lots of cases where dialogue across different countries has led to progress. We see, I'm sure we'll hear from, I think Eoin may be able to talk about the advisory group that has operated in Ireland, bringing in expertise from other countries. I know that the legislation being thought about in Slovenia draws heavily on the legislation already in place in Bulgaria, albeit adjusted for the local context. Things like that are happening all over and in different ways. There continues to be a muted response from publishers. In the countries where something is in place or even where it is proposed, there has not been a strong response. The most obvious one of those is in the UK, where letters have gone out to publishers as part of the process from many of the institutions. And in the most case, the response from publishers, particularly international publishers, has been muted. In many of the countries that we cover in the case studies, local publishing groups have offered opinions about the proposed reforms or the ways in which institutional policies may come into place, but generally the response has been quiet or well managed by those in the initiative in question, and therefore there hasn't been an extraordinary amount to point to. This is an observation I think that we may hear about later, but it is easier to transfer policy development and initiatives in the way that research policy is developed than it is legislative reform. Legislative reform is very different in different countries, and it takes longer and is subject to more interested parties. That's the next point here. And so people are often unable to simply transplant the effort that has been made in another country. It has to undergo significant change, and in fact will be to copyright reform in one country will occur and something similar will happen in a different country, but it won't actually be copyright law that is reformed. Christina, who's talking on the panel later, rightly has asked me to be clearer when I say it will affect copyright, but it may not be a copyright act that is put in place. It is called something else, or it is undertaken through the auspices of departments that are not responsible for copyright, because copyright is very often equated with the particular interests of publishers, and interested parties can make it very difficult, if not impossible, to achieve reform of copyright legislation, albeit the legislation that goes in affects the way copyright is enacted within the research sector. And I've already made the point about progress looking slightly different in different places, which is why we continue to adopt a very broad definition, because it seems important to do so at this stage. For those of you in the audience who are considering policies and looking to understand what to do if you would like to develop rights retention policies, these are some key themes that exist across all of the jurisdictions and initiatives that we've sought. Legal advice remains a really important element. Many of the initiatives that we're featuring has been launched by, or at launch have featured, very, very significant legal experts as part of them, experts in copyright law and experts in legal theory in many cases. In some of the countries, the importance of legal advice is not always to say this is exactly how you can develop rights retention in your country. Often it is to establish the parameters in which an institution launching a policy might have to operate, quantifying the risk to those involved, understanding how, the advice may not be definitive. In fact, it very rarely will be, but it will offer a grounding in which institutional leadership can talk about the options that they have and how progressive they wish to be then in launching a policy in that environment. Existing collaborations and networks feature very prominently in the case studies that we're featuring. The NA institutions in the UK are research-intensive organisations in the north of England. In Finland, the Finnish Universities Network Libraries Network, I apologise, have been leading work in this space, very well-established organisation. The Universities of the Netherlands, another one that we feature, has done work in this space over a number of years and has launched a new working group to consider how the expression of copyright can be better defined within universities. These are very well-established entities that form the bedrock of institutions. Equally, though, coalition building, I think pointing to Bulgaria and to Ireland and to Italy, where the initiatives that have been pulled together are bringing together different groups from institutions or academics or those from civil society and other non-profits with an interest in this space. So it's not always a librarian network that already exists. Sometimes it is a different grouping. It can be led from somewhere else. The initial spark can come from somewhere else. That's definitely something we're trying to pull out. And then finally, the approach to engagement of researchers and leadership and wider groups is so important. On the researcher point, we have had long discussions about the continuing presence of opt-outs within policies. So often the policy is brought in and there is an opt-out that researchers can apply for if they feel it's significant to do so. That seems like a weakness, but actually it's rarely taken up. And it's a major factor in bringing researchers on board and gaining support, or at least indifference towards the policy. They are relaxed. It can assuage many concerns. And it's a key part in nearly all of the case studies at that stage in making the case to researchers, having a dialogue with them about how their rights will be unaffected, that they will have opportunities to express their freedom to publish in different places. But it isn't simple. It takes lots of planning. It takes lots of engagement. And I think Finland's a very good example of where the approach taken is to do it in stages, to bring different groups on board at different points as things are developed. And again, I hope that's something that Susanna, who's joining us later, will be able to talk a little bit about. I'm coming up to the end of the time I have allotted, so I will just, my final slide here is just the most significant factors. This is really, again, talking about context. Everyone is operating in different contexts. Everyone is considering different things that are affecting the right kind of initiative that they're launching, how they're approaching rights retention policy development, and they fall largely into three groups. I'm not trying to be exhaustive here. This is not everything, but it is around legislation, particularly where copyright ownership sits, particularly whether there is secondary publishing right legislation, and whether it has led to authors taking up that right. It's a particular aspect of the French and Netherlands case studies that we're featuring where secondary publishing rights exist, but they aren't necessarily well taken up for complex reasons. And so the people looking at institutional policy development in those countries are having to operate within that system. National policy environment, particularly national science plans or policies, national funder policies, and the way and assessment frameworks work. Those are important aspects in both the UK and Norway, which have had the most significant advance in policies being developed. And the publishing culture, particularly the routes to open access, the ways in which open access has been achieved, and therefore the significance of green open access and institutional repositories as routes to facilitate rights retention, and the strength of culture around researchers' freedom to choose where to publish. That's a factor in a number of different places, but none more so than France, where attempts to bring in stronger or more or mandates around rights retention are very difficult because of the pushback from researchers and feeling that they will restrict academics freedom to choose where to publish. And so the conversations there are around education and developing model policies that people may be interested in taking up. I think that brings me to the end of my talk. I say that because I'm not sure what's on the next slide. And that does bring me to the end of my talk, which is around the right time. So I hope that people, if you have questions, please do put them in the chat. I'm very happy to answer any. We will bring in many people with a lot more expertise than me in a few seconds, who will therefore be able to help me answer any questions that you have. But look forward to some discussion around these topics. Aoife.
Yes, thank you, Jon. So I think that your presentation made very clear the first point from the T-shirt. So we really have a complicated situation. Luckily, we have a panel of experts representing different countries and very different stakeholder groups. So you will be actually able to answer many of the complexities and challenges. We have today here Christina Angelopoulos, an associate professor of intellectual property law from the University of Cambridge, so a very important expert in this area. And also alongside her academic work, it is worth mentioning that Christina has conducted work on behalf of European Commission, the WIPO, World Intellectual Property Organization, and also different NGOs in Europe. We also have Raúl Aguilera here. So he is a library service director from the Universidad Carlos de Madrid from Spain. He is also involved in different working groups on open science, from a Spanish network of university libraries, or UNICAN network, or LIBER, Research Data Management Group, and also from recently member of SPARC Europe board. Then we have also from the library sector, but from the north of Europe, Susanna Nykyri. She's a librarian from Tampere University, Finland, and she co-chairs their national working group on funding open science and research and working on the right retention issues in Finland. Then we have Eoin Odell, a fellow and associate professor of law from Trinity College Dublin, and he's here today primarily because he's a co-principal investigator in the SPARC project. So the project that deals with secondary right, copyright, open access, institutional policies, and right retention. So something very promising. And finally, Victoria Tsoukala is here today. She is a policy officer in European Commission working on matters of open science and research infrastructure. So again, it is very important what will happen in the domain of legal changes and right retention in the whole European research area. And now I will give word back to Jon, who will moderate the discussion. So I see that we already have some discussion in the chat, but we will save that for the end of the webinar. Go on, please, Jon.
Thank you, Aoife. And I've worked out how to unmute myself without unsharing my presentation. So I've learned something today, even if no one else does. So that's good. So to start the panel discussion, I think we would like to just ask everybody to offer some thoughts on what they have, their observations. We've been able to give the panelists a little bit more detail in our findings. And so I'd like to just go round and ask everybody what observations you have on what we've learned so far and which particular aspects resonate with your experience. Maybe I'll start with the three representatives who are working in individual countries and with their approach. And just because they're on my screen in this order, Eoin, would you mind starting us off?
Yes, thanks. Thank you for the presentation, Jon, and the introduction, Eva. You know, to a man with a hammer, every problem looks like a nail. And to a lawyer, every problem looks like it can be solved by drafting legislation. And that is one of the two things that we're doing in the SCORE research project in Dublin. The other thing is that we're drafting draft institutional policies. So we're working in parallel. We are trying to get best practice. We have stolen all Jon's best ideas from draft 1, and we will incorporate his best ideas from draft 2. And everybody else's best practice internationally, both in our draft institutional policies and in our legislation. And as you said, legislative implementation differs from country to country. And sometimes it's a straightforward creation of additional exceptions in the copyright legislation. But we have seen by looking at the other jurisdictions that have done it that way, that there are problems with doing this. As you said, trying to persuade governments that copyright needs amending is often trying to persuade them to change the interests of publishers. And so rather than saying amend the copyright legislation, another strategy is to say that the ways to vindicate institutional open access, the ways to vindicate secondary rights and rights retention, secondary publishing rights and rights retention, is simply to create a workflow that researchers can take advantage of, that institutions can implement, and to give legislative support for that workflow, and to be careful as to how to draw the line between that and publishers' subsequent interests. So that's what we've been doing in our draft legislation. We have, over the last year, been consulting as widely as we can about what needs to be in that legislation. And the key proposals are obligations not on researchers, but on their institutions by and large, to create this open access publication workflow. But acknowledging the individual interests of the authors, with the exceptions and carve-outs that Jon mentioned, knowing that the mere fact that they are there is reassuring, but it's rarely going to need to be invoked. And then developing institutional policies that reflect those workflows. So our legislative strategy is, in European terms, to see it within the competence of DG Research rather than DG Justice, to see it as standing in its own terms rather than as an amendment to the Copyright Acquis.
Thanks, and that's a really nice way to put it as to which of the two it sits under. Maybe I could ask you, Susanna, as the other representative of one of the case studies, would you mind offering your reflections on what you've heard and which particular elements resonate?
Thanks, Jon. I think that we share the same need here to ensure equal and long-term access to research articles. But for instance, this issue is even more complicated if we consider also books. So my perspective represents more at a more concrete level. We are in Finland considering these articles. And articles, they are not published and read in national silos. Science is global, so also local is global. And what resonates with me perhaps most is this new community of practice, which is much needed and benefits all, also the forerunners, but especially us who are very much doing now work in progress and actively still seeking our research right retention strategy. And I appreciate the community a lot and want to use this opportunity for thanking SPARC Europe, Jon, and the active whole community for that. So what resonates with me most is the people who are supportive and helping each other to find the best possible solution in this very complicated situation. And as Jon has brought up, so one size does not fit all. But however, I have been happy to see that we can learn from each other, and the different ways of promoting rights retention strategies help to specify what needs to be considered in each context. So, for instance, we in Finland, and what may be helpful. And although today seems unrealistic to expect Finland to reform its copyright law in the coming years, we can still do a lot meanwhile. I appreciate that the report clearly highlights that there are many effective methods, but none are perfect. And yet we can still see that success in this promotion work is achievable. Thanks.
Thank you very much, Susanna. And Raúl, would you mind going next as the third of our representatives who are actively pursuing this kind of process? I think you're muted, Raúl.
Yeah, thank you, Jon. Thank you all for being here. And I think it's really a challenging time for us all, because we need to face not only legal reforms or new policies in institutions, not only gathering people in a single objective. It's like a matter of culture change. And culture change on the one hand, and on the other hand, also the interests of the companies that don't want to release those rights that are not theirs, but on the contrary, have been given to them by the authors. And in the end, the authors are in the center of what we are discussing today. And they are, I would say, the most vulnerable variable in the equation, because they cannot defend themselves. So what's the best strategy for that? Well, I actually don't know. I think one of the good things of your analysis is that, well, all the roads lead to Rome. There's no perfect strategy, and there may be different approaches that we can set up in different countries. For instance, in Spain, we have set up a working group in the Spanish network of university libraries. We are cooperating with other institutions like we are going to cooperate with the Spanish Federation of Museums and Library and Archives Association to try to find ways to push towards legal reform, which is great, but maybe also to find alternative strategies. Actually, in Spain, the law says something that is aligned with secondary publication obligations, because the authors that are publicly funded are required to upload their papers in the repositories and make them available, accessible. And but in the end, there's a mixture of different traditions in the law. We have the law of the general law of intellectual property rights, where everything belongs to the author. And we have the law of science, where apparently everything belongs to the institution. And however, the law of science is like always talking back about the general law of intellectual property rights. So this is, I don't know if this is a gap or a loophole or whatever, where things are not yet fully aligned. So I think finding ways to solve these problems in the legal framework, or how to help researchers to cope with these problems when they in a daily basis they deal with researchers, I think that's something really worth trying in the next few years.
Thank you very much. I wonder if I could ask Victoria, would you mind going next to offer your what you found interesting or particularly resonant?
Yes, thank you. No, the results are very encouraging as I see the first results of your project. I mean, we all know that removing legal obstacles has been an aim or a desideratum in open access since forever, since the 2000s. But it's understandable now that institutions and funders and countries really are coming together to act. I would concur that it seems that the plethora or the mosaic of approaches reflects the richness of the different countries and of Europe, the different situations. So complementarity and collaboration is key, I think. It looks like in many cases from from your work, that we can see how, for example, SPR works together with rights retention, etc. So I think it needs to work at the same level, at the same time, in different levels for something to be thoroughly effective. So I think it looks like it's quite promising, because we see different elements, like the institutions, the funders, the member states being mobilized at the same time. And when we have all of these components, I think we may be not relatively sure, but okay, auspicious that things may turn out quite well. On the other hand, I can talk with my hat as a funder, that our current Horizon Europe, of course, has rights retention policies, and we've all seen that funders have been quite interested in implementing rights retention policies, especially the Coalition S group of funders that I think provided a bit of impetus to institutions. And so now I'm happy to see also through your study that there is a lot of work going on at the institutional level across Europe, but also at these other two levels, the funders and the national law and national action that will bring the whole thing together and make it into a workable system. So I'm quite pleased with the results that I see from your study are quite auspicious. It seems that things are starting to come together, let's say. It's still the beginning, as you mentioned in your presentation, but we have a lot more to see, but there is coordination, let's say, that seems to start to be happening. So
Yeah, thank you. That point around different levels and the importance of the connection between funder and institutional policies is a very important one, and one that we made a lot in the first phase of the work, where we were focused on different things. And I hope it comes through in individual case studies as we articulate how particular funders have had a particular impact in different contexts.
Yes.
But thank you. That's a really important point. And then our last speaker, but no means least, Christina, would you mind? What have you found particularly interesting or relevant?
Right, thank you, Jon. Yeah, of course. So I think perhaps I would relate to what Eoin said earlier about how when you're a lawyer, it seems as if all problems have a legal solution. And there is certainly that temptation. At the same time, I think one of the things that jumps out to me in this regard is the relative lack of effectiveness of the legal solutions as opposed to the change of culture, the work of people on the ground, the impact of funders stimulating, like you say, institutional change and education of librarians, of researchers, in order to change the assumptions under which we all operate. So one of the things that jumped out to me, Jon, was the fact that, as you pointed out earlier, the two countries within the study, within the collection of 10 countries, which seems to have the greatest proliferation of rights retention policies, are two countries which don't actually have an SPR, a secondary publication right reform, to date. So I found that interesting. At the same time, I certainly don't want to imply that lawyers are unimportant in this process. I would never want to imply that, because that would render my involvement irrelevant. So I have an ulterior motive here, apart from anything else. But I think perhaps it also goes back to that thing which Eoin mentioned earlier, which you've already pointed out. What do we mean when we talk about reforming the law? So obviously, copyright springs to everybody's mind in this regard. Like you pointed out, one of my observations when reading the case studies was that it all goes back to reforming copyright law. Now, Eoin pointed out that from a strategic perspective, it doesn't always make sense to approach this as a change of copyright law, as an amendment of copyright. But beyond that, perhaps there's also the question of what kind of legal change do we want to achieve. So copyright is mostly focused on rights. Perhaps to the extent that researchers need to be prodded or educated in order to apply their rights, a better legal reform is via obligations. And that really does come back to the question of research and how do you best promote especially publicly funded research. So I'm really intrigued by this question of how can we change the law in order to introduce mandates, in order to introduce obligations, and what is the obligation, especially of research institutions as employers of researchers, in incentivizing this change of culture.
Yeah, that's very interesting. Thank you. We haven't gone into too much technical detail around secondary publishing rights in this discussion for obvious reasons, but I would note that in Bulgaria, they've taken a very planned approach to secondary publishing rights, secondary publishing obligations, and those, having made those two reforms, they're now moving into a phase of institutional policy development to make sure that those legal reforms that allow authors to do certain things and oblige them to do certain things are actually enacted. So that's there. And I'm pleased that we have Sorry, say that again.
I said, which is essential.
Absolutely, the connection between them. Maybe I can come back to Eoin, just because you referenced him, Christina. Eoin, you taking this parallel approach, which you articulated, how important is that connection, as you see it, between the legislative reform, the secondary publishing right, and the rights retention in parallel?
I'm going to take a step back first and just say that the reason why we have looked to achieve the same effect without using that language and without using the language of copyright is because I was chair of a copyright review process about 10 years ago, and the government did all our boring technical stuff, but none of our really interesting progressive stuff, because the publishers and other interested parties pushed back on all the interesting stuff. Now, it didn't really have an impact on them, but because it had an impact on copyright and because they have a sort of an institutional ownership on copyright, they pushed back. So strategically, learning from that, that's why we're doing we're not using the language of retained rights. We're not using the language of secondary publishing, but we are adopting Christina's point about obligations and so on. We're creating workflows that have, and legislative support for workflows that have the same impact. We're not saying that the authors retain rights. We're not saying that there are secondary publishing rights. What we are saying is that the version before the publishers get their grubby little hands on it is a version that institutions have to ensure will be made available on an open access platform, which is functionally equivalent, and then saying that that version can get shared from the platform or by the authors or by the funders and so on. So we are functionally achieving secondary publishing rights and rights retention without using that language and without saying that it has an impact on the publisher's subsequent copyrights, entirely to ensure that we don't get the pushback this time that we did last time. So that's why I said at the end of my comment, it's closer to DG Research than it is DG Justice. In Irish terms, it's the Department of Further and Higher Education rather than the Department of Enterprise. So there are many ways to what is it, skin a cat, crack an egg, whatever. And in those circumstances, we're being quite expansive in what our impact is, but not in the copyright language that we're using. So the very last point that Christina made, I think we're demonstrating.
Thank you. And I note actually that the point I made earlier about a muted publisher response, I did emphasize, in part that's because people have worked very hard to manage the communication and the way in which publishers are affected. So this is an example of, it not being reform of copyright because that caused significant pushback from publishers. That's one example of the way in which people have managed that.
Jon, can I just jump in and answer two questions in the chat that are directed to me? There is a question from Katie and a comment from Jen Smith. So Katie, Eve, and Jen Smith about are we talking about obligations relating to the preprint or the author's accepted manuscript? One of the things that we have noticed is that using the language of the open access community in legislation doesn't work, because you end up with all sorts of discussions at the margins and ambiguities and so on around what is a preprint, what is an author's accepted manuscript. So we're not using that language. We are just simply saying that the last version before publication, that's when the obligation, the workflow obligations on the employers kick in. So that's the first thing. The second thing was, when will the legislation happen? Well, to use another metaphor, how long is a piece of string? We had an election just before Christmas in Ireland, and we wrote to all of the candidates in that election. There was a second stage of the election for the Senate just last month, and we wrote to all of the relevant candidates in that. Once they were elected, we then wrote to all of the people who had been elected. Then when there was a negotiation for government, we wrote to all of the people involved in the negotiations for government, and we telling them what we were doing and asking them to adopt our bill as an obvious quick win. You know, legislators like to be able to point to legislative outputs like we have to point to our research outputs. And we are now engaging with the relevant government department. I have absolutely no idea how they are going to respond. If they adopt it, then we could expect the legislative process to start, and that could take 2 years. On the other hand, the copyright process that I talked about, that I was involved in, between our report in 2013, the legislation was 2019, and this was a report that the government wanted. And if the government
so quite broad range of possible outcomes.
Yeah, and I was going to say, if we have to go via backbenchers, then that's going to extend the time even further. So we have quite an exciting draft, but I don't know whether we will excite the legislators.
Could be some time. Maybe I could bring in Raúl. You were talking a little bit with your observations around the connection between legislative reform and the policy development. How important is that connection in the Spanish case, or how important is it in your eyes?
I think that's a very good question. I am going to say something I don't want to say, but I need to say it anyway. It is that I'm skeptical about legal reform, not in itself, but on being able to adapt to so many changes that are taking place so quickly in the world. It's not a problem of Spain. It's, I think, a problem everywhere. Legal reforms are always behind reality. And in the meantime, I think we need to find some ways to continue advancing. So, well, in our landscape, in the Spanish landscape, there's some room for lowering secondary publishing rights, and there's also some secondary publishing obligations. And but the point is, as I already mentioned, is that there's some contradictions or some gaps in the legislation. One of the things that I think is more complex in the law is that when the law grows complex and there are many amendments across time, these may lead to different interpretations. There's also some room to finding alternative ways not to comply with the law. So when I think about right pretensions in our country, for instance, I think that it's more efficient to adopt some policies in the funding schemes of the government or for instance, from the European Commission. Because if the funder says, you need to retain your rights and you need to publish in open access and you need to publish with an CC BY license, that's enough. Because you need to comply with that if you want to get the money. So it's like a carrot approach rather than a legal approach. But I think it's working. So I'm sure we will need to smooth the law regulations to make everything aligned to the same side. But I think that before we have the legal framework in the best way we can, we have the funders' requirements that are working so fine. So that's my approach.
It's very interesting. It was so easy to get to some of the important differences in different countries just very quickly. And I'm going to immediately ask Susanna if she would mind speaking, because I know from your perspective, Susanna, legal reform was something that you've explored, but isn't the focus of what you're doing.
Yes, thank you, Jon. But first, a little bit about muted publishers. I'm also publishing manager of Tampere University Press, which is a Diamond Open Access publisher. And even in small countries like Finland, the publishers represent different voices. And perhaps the open access publishers, although already common in Finland, are not enough heard. And yes, I do agree that there is still this need for legislative reform, but I would like to broaden this rights perspective. So, although this access to research and its benefits is very important, and it's not only an issue for legislation and for research and doing it well, it is also a human rights issue. So we do not need to make research open and ensure its long-term accessibility and economic sustainability only for the sake of better research, but to allow everyone to enjoy and experience their full capacity and as individuals and members of society. So I think this rights retention strategy and all these rights discussion goes well hand in hand with ethics. And I would like here now to cite the Universal Declaration of Human Rights, Article 27, it's very short. Everyone has the right freely to participate in the cultural life of the community, to enjoy the arts and to share in scientific advancement and its benefits. And yes, also Finland is committed to the declaration. So therefore, regardless of delays in legislative reform, we also in Finland need to invest in education and training, develop better support processes, and create consistent guidelines, which we are aiming at to have these shared practices with all the universities. And we still need to strengthen the network and cooperation among our open access specialists working in different institutions, especially in libraries. So what we are aiming at now in Finland is not, I think it's not actually plan B, but it's also a very essential part of this rights retention strategy. And naturally, it would, of course, be more straightforward and faster if we already would have our legislative reform in place.
Would you mind just describing, which group is involved in your initiative? Who is it that's leading it, and how are you engaging other parties?
Yes, well, I think, in the beginning in Finland, we had very open and broad discussions under the National Coordination of Open Science. And it was pretty chaotic, I must say. And it became clear that we are not sharing the same I think, background information. There was not enough agreement on basic issues. So there was a lot of misunderstandings, simply misunderstandings, I would say. So it was better, we in the university libraries considered that it's better to take a little bit, step backward in that sense, that as a smaller group to start to consider what would be the best practice in Finland, what to recommend. And the University Libraries Network has a working group, established working group, which I'm chairing. And I noticed that there are many members here participating also this webinar, which is nice. So we have been already over a year now considering what to suggest to university presidents. And it's clear that already that we are aiming for that kind of shared practice between different universities. if we would aim to have the same practice between all the research performing organizations, so that would be too huge task, I would say. So we are now moving forward step by step, I would say. And there are still many tricky questions we are discussing, which are complicated even between different university libraries, like this licensing question, what to recommend or demand, what to suggest.
Thank you. I wonder if I could ask Victoria, from your perspective, which is a different one from others, how important are the different collaborative initiatives that you see or get involved in? Do you have a view on where these are best begun, or which parties are best engaged in the process?
What we definitely know is that it's never begun by the researchers, right?
Yeah.
That's far we can exclude them. I mean, funders started it recently. I mean, look, the most significant actor in this all is clearly the university and the research institution, right? It has the power, and everything begins and ends with it. The question is, will it start the initiative itself? I mean, I think there are, in different cases in different countries, we've had, you know, it has happened in different ways, right? For example, I mean, you see a university such as Harvard, it's not rocket science. It's had this since 2008, if I'm not mistaken. So we are a bit like close to 15 years behind in trying to institute something like this. Then funders, of course, have their own reasons. The Commission as a funder and other funders in Coalition S want to make sure that their research is as broadly used. It is open access because that's what we require, and that there are no obstacles in this, including legal ones. So we want it to be able to be reused, to be preserved, etc. So we set our own terms, which often, of course, influence the what the institutions do, and especially, I mean, the Commission and Horizon Europe may have a little, you know, has an effect on what member states will do at the national level, at the funder level. I think we've seen different things in different countries. So I can, but you know, I cannot think as an archaeologist who first started it, but certainly, I mean, the librarians and the libraries that also have a very strong role in potentiating institutions and raising awareness of things that sometimes the researchers or the administrations are not, you know, up to, have also been a source of activity. But I think, again, as I said in the beginning, it's very nice to see now that the activities at very many different levels at the same time, which means that they're likely to coordinate in the future, especially, for example, institutions and funders. It's quite important, the funders, also for the alignment of policies, of such policies that enable researchers to work across the globe, right? Because research is global. And then to think if we need legislative intervention as well. But for me, I think also, I mean, the Commission is thinking, and maybe we can get this in the end, about legislative act on this. Nonetheless, probably the most important work that's expected at the level ultimately of the institutions. So we expect, and as I think Christina said and others said, we expect this slow and painful change in cultures, in researcher cultures, in research assessment also as well, of course, because if you're putting the researchers into the conflict of providing the open access and maintaining their rights for the Commission versus progressing to be a full professor or what have you not in X journal of X impact factor, that's a problem. Therefore, I mean, the institutions that are the home of the researchers, that produce and consume the researchers, are the most critical actor in the whole of this, I think.
It's really interesting that you mentioned Harvard, because Eoin was kind to say that they drew on our first phase report and Retain. But one of the things that was striking in that first phase report was looking at the Harvard policy and the approach that Harvard took and the result of it, and how much actually still translates into the approach that people are taking today and what's happening and how things are playing out. So it's not that everything is new. It is significant things learned across different jurisdictions and approaches.
And of course, when the time is mature, right? Because again,
Yeah.
I think, as I said in the beginning, these are not things that we didn't know 20 years ago. It's just probably that at the time we were struggling with, actually making the content open. And then once you start making a significant part of this open, then you manage to have a grasp also of the details and or what's blocking it from being open. And so it's it's a learning process for everyone involved, clearly.
Yeah. I'm conscious that we're coming towards the end of the time we have available for the discussion, and there's a couple of other things I want to ask. I'd just like to ask, would any of the other panelists like to say anything about the nature of different collaborative initiatives, the ones that you're involved in or what you've seen? Is there anything you'd pick out as particularly important for people who are part of or thinking about how to approach this and who to involve? Okay, I don't see anybody putting their hands up, which is absolutely fine. So I'll go. Maybe I could go back to Christina. I don't know if this is putting you on the spot, Christina, but I do want to just return to that point about it's easier to transfer policy across boundaries than it is to transfer legislative reform. Are you able to say anything about why it's difficult to transfer legislative reform across different boundaries in the region of copyright or secondary publishing rights? What makes it, I mean, the UK and Norway have had success in particular legal jurisdictions without secondary publishing rights, and others are finding that legislative reform is slow and hard to transplant across boundaries. Can you offer us any thoughts on why that's the case?
I'm not sure it's difficult to, well, I don't know whether it's difficult to engage in legislative reform, because I think that has to do with everything that Eoin was talking about earlier. Who do you approach? How do you approach them? What sort of language do you use? And that probably differs from jurisdiction to jurisdiction. I think if we really wanted to, if the policy will was there, for example, the European Commission, if they decided to do it, could just introduce a European-wide policy tomorrow, and then it would apply or have to be implemented across the entire European Union, and that would be perhaps even simpler. But the legislative will would have to be there, and that how you get that is the tricky issue. Another tricky issue, though, is if you want to pursue legislative reform, what should that look like? And I think that goes back to the relationship between rights retention, secondary publishing rights, secondary publishing obligations, because the basic problem here is, again, a cultural one. So like Victoria was saying, researchers are not the solution, because researchers are just reacting. Researchers have their own incentives. So what we have to be trying to do is change those incentives, because in a way, if you look at just the law itself, there is no problem, right? Researchers have their copyright from the very beginning. The problem is that they have incentives that make them turn around and give their copyright away essentially for free, even when the works over which they have copyright have been funded by public funders, or they've produced it as part of their employment by a research institution. So the question is, how do we change those incentives? Now, one way is to ensure that even when they turn around and give away their copyright, they can't. So that's where the secondary publication right comes in. Whatever you give away to publishers, you still retain the right to publish. And then the question to make it available online for free, essentially to enter into competition with publishers, although I guess that's not something we should be saying out loud. Then the question is, okay, researchers, if they have this right, how do we encourage them to use it? And I think that's probably why we're not necessarily seeing progress in countries that have the secondary publication right, because researchers have it. They either don't know that they have it, or they're not interested, incentivized in using it. So that's where the obligation side comes in. Now you have to create an obligation for researchers to use their rights, whether they come through rights of retention or a secondary publishing right. And that's where I think things really get into the cultural aspect of things and the relationship between law and culture, because that to a large extent goes back to academic freedom and what we define as academic freedom. And we saw in your study, in the case studies, Jon, I think it was in France, in Nantes, this idea came forward, which has been put forward in other places as well. There were also some examples of cases in Germany, I remember, in the past. The idea that if you impose an obligation on researchers to publish, to retain their rights and to publish in open access, then that is infringing their academic freedom. I've always thought that was a really, really curious idea. I'm not convinced that academic freedom is impinged in this regard. So perhaps another form of legislative reform that could help you and could actually help shape the culture would be to simply clarify what we mean when we talk about academic freedom. Is academic freedom engaged by movement in these areas? I don't know if that answers your question.
I think it does, and I think it goes beyond answering the question. I think it's very interesting that the point you make there about academic freedom, again, where the policy development has progressed and has been successful, actively people have used the language about the way in which people have engaged researchers has actively taken on that argument, engaged with that conception about academic freedom. But in some places, the culture is very strong and there is not sufficient momentum, established process, policy development, legal issues. There are lots of things that make it more challenging. I think a couple of points I would make before we're going to come to the questions. So if anyone has any questions, please do add them to the chat. There was a discussion in the chat a few minutes ago about that not all publishers are in opposition to rights retention policies. Many, you said, Christina, is in competition with publishers. Many publishers a significant number of publishers have expressed no issue with these policies. They believe they add sufficient value outside of it that it's not a threat. There are definitely some. I just refer people to the
traditional publishers, not.
I understand.
Yes.
I understand, but I just refer people to the chat where there was some discussion of that earlier. And then, so if I finish, I'm going to ask about. So please, if you have any questions, do put them in the chat. I'm going to ask now about European level changes that might encourage more rights retention development. We've talked a little bit about this, but I know this is a topic that people are particularly interested in. So if anyone in the audience has thoughts on this, we welcome them in the chat as well. But maybe Victoria, I could ask you, for obvious reasons, ask you first. What do you think, what European level changes might encourage more rights retention development?
Yes. I mean, I will refer here then to our current activities. As you know, we have identified, also with the help of Christina and other colleagues, various problems with current legislation in terms of, creating barriers to access to research for researchers and reuse, right? The Commission would like copyright and data legislation actually that is fit for research. So, and to do this, we have embarked on, and this is a very important actually element of our European research area policy. So you are probably aware of this concept, the European research area, which is a unified European space where people, idea, goods, etc., circulate freely, and of course, scientific knowledge is a critical aspect of it. This idea actually, which exists already for 20 years or more, I think, was revamped in 2020 with the new European research area communication. And then through it, we have an ERA for short, a policy agenda. So this issue of trying to see what we need to do so that we have a copyright and data legislation that's fit for research is a major part of our policy agenda until 2024 and in the coming few years as well. So we've already commissioned studies like Christina's, for example, that she did for us, and also a large-scale study which was published last year to inform us on what the next steps are. And we will not hide that one of the options that are being considered is legislative action at the European level. You know that we have announced that there is going to be a European Research Area Act, and this is part of the work of DG Research. And as Eoin said earlier, if something is going to happen, it's not going to happen by by editing, actually changing the copyright law, most likely, it looks like, but by trying to do something in the research realm and law that concerns research, actually also because, I mean, we wanted to provide the focus on research specifically so that digital law and copyright law are, support researchers. So, so in the context of the European Research Area Act, one of the possibilities is that we could see something that would be along the line of a European SPR, legal intervention, let's say. So that's one point. One possibility, rather, and another possibility, of course, would be to not to not intervene legally, but rather to stay at the level of guidelines, etc., etc. So that's the second possibility, and there has not been a decision yet. We are doing all we can to inform ourselves and to create a final list of options of what would be best to do. But by studying, of course, the European landscape as it is, and as you have also presented through the Retain project. So this is what we are expecting in the next year. I mean, we're expecting it to pick up in this year, and if we have, and I think what we will do will be announced, I think, next year, not this year. Which way we will go, which path we will take. And this, of course, will mean also taking the opinions of stakeholders, of member states, and all of that. I mean, different interests and opinions will need to be taken on board to make a decision. And of course, right now we are ahead of the new framework program. That's another way of us influencing, policy. So the current one says that we will retain, that beneficiaries and authors must retain sufficient intellectual property rights to provide the open access as we want it, which is immediately and then with CC BY licenses. So we're working towards seeing what the next framework program will deliver, which is usually quite, as I said, influential in terms also of national policies, funder policies, and institutional policies.
Thank you, Victoria. That's very very helpful. I'm sure it'll be of interest to many people here to hear it explored in that depth. We've got a few minutes left. Would any of the other panelists like to say anything on this topic before I dig into the questions in the report? Raúl, please go ahead.
Yeah, I am actually thinking that obligations from the funders or from the governments are a very good way to push towards the cultural change. But I also think that cultural change is based on beliefs, not just on obligations. So we would need to change those beliefs in researchers. The European has also this incredibly clear framework of competences, digital competences. There are the ones for educators, the digital model, and the research for researchers. And in both of them, the knowledge or the understanding of the scope and meaning of intellectual property rights are at the core of many of the competences that are involved. And I think it's our duty as librarians, and here I am speaking from this point of view, to work with the universities and research institutions to help train researchers. Because otherwise, we know that publishers and the big publishers are out there, and they are longing for act on behalf of the researchers, trying to sort of defend their rights when they just want to make more money from the resources they have. And this is one of the reasons why when some researchers are accepting NC licenses, they are not actually doing what they are not conscious about what they are doing. They don't actually know what that means, because they say, well, non-commercial, but non-commercial for the others, because this is commercial for the publishers. So I think researchers, as I already mentioned, these are the most vulnerable part of this equation, and we need to help them. We need to make them aware, and of course, at the same time, I think it's a good practice to go for obligations.
I'm having trouble unmuting again, and Susanna, you put your hand up. Please go ahead.
Thank you. Well, I start first from national aspects, but it leads to European perspective and reality, and something which I think is very relevant in this context. So what is special about Finland is that the majority of Finnish journals are produced by learned societies, and it has already become common for them to transform into diamond open access model. So in Finland, researchers do a tremendous amount of labor to enable publishing in the Finnish language and on topics especially relevant to the Finnish context. And they usually do this for the sake of science, so that the articles can have an impact on research and society at large. And this effort also aligns with universities' third main task, which is societal interaction in addition to research and education. So therefore, while promoting secondary publishing rights, we need to actively develop also ways for institutions to better integrate these editorial tasks as part of scientific work and to value them in merit systems. And there is a lot of promise in this regard within the context of KORA at European level, but we are not there yet. And so I think we also need to ensure the necessary infrastructure, support and training for open access journals. And this requires financial investment, and developing an effective model has proven to be very challenging and prolonged process in Finland and also elsewhere, I think. So there are differences, yes, but despite the differences, we all have only 24 hours in a day. So therefore, if we want scientific publishing to remain in the hands of the scientific community, I think we need to allocate the necessary time and effort to achieve this. And that is why I would like to emphasize the needed development work to be done also within the context of KORA, and I think it's very relevant also for this right retention strategy and policy issues for all of us.
Thank you, Susanna. Looking at the chat, there's been quite a lot of discussion in the chat as we've got along. Eoin, you answered a couple of questions that were directed to you already, and I think the third has also been answered in there. I note we were talking about academic freedom earlier, and I think Ross Mounts has rightly put in here, academic freedom is what you study, not where you choose to publish, his opinion, but academic freedom being a broader concept. And absolutely, actually, as and when the report is published in the next few weeks, you will know we've been very specific that the factor that's most important is the culture around freedom of academics to choose where to publish. So that's one element of academic freedom, and it's culturally stronger in some places than in others, and it's a major factor in how rights retention policies develop, how strong they are, whether they're mandates or recommendations, and in particular in France, it's led to the legal action that Christina was talking about. There's some other discussion in here. I make a point that I emphasised here. This is an open forum. We've invited, there are lots of broad range of people in attendance. Everybody is welcome. Retain One, we spoke to a huge range of people about this topic. We spoke to lots of publishers, we spoke to lots of funders, we spoke to lots of umbrella bodies, and I would say two observations. We made the point, one of the recommendations we made in the first report was around polarization and people feeling very emotional and strong feelings on both sides. An observation I would make is 2 years on, I feel this is a less polarized debate. I feel there is less heat in this debate between parties who might have considered themselves on different sides before. And I think I welcome that. And I feel like we are engaged in complex, nuanced discussions. And when I say response from publishers has been muted. I know lots of publishers are engaged in discussions in different places and in different jurisdictions, and that should be welcome. So those are a couple of other points. But I don't think we have any other questions to answer. So I would like to just quickly thank our fantastic panel and for their contributions and participation. And I'm going to hand back to Aoife to bring us to a close.
Well, thank you a lot for all the insights and your knowledge that you share. I will, for the end, just share a slide, just a moment. So a slide with some resources developed in the Retain project that I would like to invite you to take a look at. You will all receive presentations, and there will be a recording. So, and of course, one thing that is very important, if you haven't yet, please, if you are interested in this topic and want to share experiences, please join our community of practice, our email list. There is a link here, and if Clara can, yes, there is already a link in the chat. So please join. We will continue with these meetings, and looking forward to any new developments in this area that will lead us to more change and more freedom in opening up and reusing scientific knowledge. Thank you all for participating.